Imagine you are making a crucial business deal, shaking hands on what you believe are all the agreed-upon terms, and then signing a lengthy contract. You trust that everything you discussed is now formally captured. But what if a clause in that contract says it is the only agreement, completely ignoring any earlier promises or understandings? This is where the powerful entire agreement clause comes into play, and its implications are far-reaching for any contract you sign. Yes, an entire agreement clause can indeed be challenged, but successfully doing so is often quite difficult. This clause is specifically designed to create legal certainty by stating that the written contract represents the complete and final understanding between the parties, superseding any prior discussions, negotiations, or agreements, whether spoken or written. It is a cornerstone of contract law, aiming to prevent disputes about what was or was not agreed upon outside the four corners of the final document. The primary reason these clauses exist is to invoke the parole evidence rule, a fundamental principle in common law. This rule generally prevents parties from introducing evidence of prior or contemporaneous agreements that contradict or vary the terms of a written contract, especially when that contract is considered a complete and integrated expression of their deal. An entire agreement clause explicitly declares that the contract is that complete and integrated expression, signaling to a court that nothing outside the document should be considered part of the agreement. This provides stability and predictability in business dealings, reinforcing that the final signed document is paramount. While challenging an entire agreement clause is an uphill battle, there are specific, narrow circumstances where a court might allow it. For instance, if you can demonstrate that the contract was induced by fraud, meaning one party deliberately made a false representation to trick the other into signing, a court may set aside the clause. Similarly, if there was a mistake in the drafting that led to a misunderstanding of a fundamental term, or if the clause is deemed unconscionable or illegal, its effect might be limited. It is also possible to argue that the clause itself does not cover specific types of precontractual representations, such as certain warranties or promises, but this requires very precise drafting analysis. Understanding these nuances can protect your business. For example, some contracts include specific carve-outs, explicitly stating that certain representations or warranties survive the entire agreement clause. Always scrutinize whether the clause attempts to exclude liability for misrepresentation, as many jurisdictions have laws preventing parties from contracting out of liability for their own fraud. Knowing the difference between an honest precontractual representation and a fraudulent one is key to determining the viability of a challenge. Remember, this content is for informational purposes only, not legal advice. In essence, while entire agreement clauses are formidable legal tools that aim to close the door on past discussions, they are not entirely impenetrable. Their strength lies in promoting clear and final written agreements, but their enforceability can be scrutinized under specific legal doctrines like fraud, mistake, or unconscionability. Being aware of these potential avenues for challenge, and conversely, being meticulous in ensuring your written contracts accurately reflected all agreements, is crucial for navigating complex business relationships and safeguarding your interests. Always consult a qualified legal professional for specific situations.